Hey, it's Taylor Swift. Obviously, I'm not, but if I'd been trying to deepfake her saying that, I could be in trouble under a trademark application she just made. Last week, Taylor Swift filed 3 trademark applications with the USPTO. 2 of them are sound trademarks covering her voice speaking specific phrases, "Hey, it's Taylor Swift," and "Hey, it's Taylor." The third is a visual trademark covering a specific image of her on stage, described in the application in detail down to her pink guitar, silver boots, and iridescent bodysuit. This was not a routine IP filing. It's a legal strategy being tested right now in real time by some of the most sophisticated IP attorneys in the entertainment industry. And the reason they're doing it is the same reason you should care about what I'm about to tell you today. AI-generated deepfakes are a real and growing threat to every creator's voice, likeness, and identity, and the law is still catching up. Now, Taylor Swift has resources most creators don't. She can afford to pay a lot to hire attorneys at Venable to file trademark applications on her specific voice phrases and test new legal theories in federal court. That's not an option for most people. But here's the thing. The front line of protection for most creators isn't in the courthouse. It's in the contract before you sign it. Let me describe something that happens more often than you might think. A creator signs a brand deal. Standard-looking contract, a couple of pages, nothing that jumps out as unusual. They create the content, post it, cash the check, move on to the next thing. And then months later, they see their face in an ad they never agreed to, their voice, their style, promoting something in a way they never consented to. And when they go back to the contract, it's all there in plain English, buried in language they didn't understand or didn't notice when they signed. But that doesn't have to happen. I'm Julie King. This is Spellbinding IP, Patent, Trademark, and Business Strategy. Today, we're going through the 8 contract clauses in brand deals that strip creators of their rights in plain English, including the AI replica clause that Taylor Swift's legal team is working to address through trademark law and what you can do about it contractually right now. I also want you to have something concrete after this episode. I've put together a free 2-page brand deal red flags checklist, 8 questions based on exactly the clauses we're covering today. It's free at kingpatentlaw.com or use the link in the description. If you're the kind of person who grabs the resource before you forget, go get it now. I'll wait. For everyone still here, let's get into it. As a creator, you start with something important on your side, copyright. Under U.S. copyright law, in most situations, the person who creates a work owns it. The moment you write, record, film, or produce something original, you own the copyright in that work. That's the default rule, and it's a good one. Brand deals are, in many ways, an attempt to change that default rule. Brands want to use what you create, and that's fine. That's the whole point, and that's why they're paying you. The question is, on what terms? The difference between a reasonable contract and a rights-stripping one often comes down to a handful of clauses. Most creators can't tell the difference because no one has explained what those clauses actually mean, and that's what we're fixing today. The first clause to look for is broad license language. Specifically, watch for the words all rights, in perpetuity, or worldwide license appearing together without any limits on how, where, or for how long the brand can use your content. Let me define those terms because they sound like legal filler, but they're not. All rights means every type of right associated with the content. The right to display it, reproduce it, distribute it, create derivatives from it, and use it in advertising. All of it. In perpetuity means forever. And worldwide, of course, means in every country on Earth. Put those together, and a contract that grants the brand a worldwide, irrevocable, royalty-free license to use your content in perpetuity for all purposes is giving the brand unlimited rights to your content forever, everywhere, without ever paying you again. You still technically own the copyright, but you've given such a broad license that ownership doesn't give you much practical protection. Compare that to a reasonable license. brand may use the content on its own social media channels for a period of 6 months following the posting date for the sole purpose of promoting the specific product described in the agreement. That's limited. That's proportionate. That's what a rights-respecting license looks like. When you see broad, unlimited license language without those limits, that's the first red flag. The second clause is work for hire. This one goes further than a broad license because it doesn't just give the brand extensive rights to your content. It says the brand is the legal author and owner of your content from the moment you create it. Let me unpack what that means under copyright law because this is where it gets important. In 1989, the Supreme Court decided a case called Community for Creative Nonviolence versus Reed, a nonprofit organization that advocated for people experiencing homelessness hired a sculptor named James Earl Reed to create a sculpture depicting a homeless family for a Washington, D.C. Christmas display. There was no written contract. The nonprofit provided direction and paid for the work. Reed supplied his own tools, worked in his own studio, set his own schedule, and did the actual creating. When the nonprofit wanted to take the sculpture on tour and make copies, Reed said no. He claimed he owned the copyright. The nonprofit said it was a work made for hire, so they owned it. The case went all the way to the Supreme Court. Justice Thurgood Marshall wrote the opinion for a unanimous court. The court held that whether someone is an employee or an independent contractor for work for hire purposes depends on common law agency principles, and it gave us a list of factors to use in that analysis. Things like whether the hiring party controls the manner and means of production, who supplies the tools and workspace, the duration of the relationship, and the method of payment. Now, Reed, who supplied his own tools, worked from his own studio, set his own hours, and wasn't supervised day to day, was an independent contractor, not an employee. Why does this matter for creators? Under the Copyright Act, a work made for hire by an independent contractor only qualifies as work for hire if it falls into one of 9 specific categories listed in the statute, and there is a written agreement signed by both parties expressly saying it is a work made for hire. Those 9 categories include things like contributions to collective works, translations, supplementary works, compilations, and parts of motion pictures. Now, they do not include most social media posts, brand videos, or sponsored content in the way most creators produce it, which means a work for hire clause in a standard brand deal contract applied to a creator who is clearly an independent contractor producing content that doesn't fit those 9 categories may not be legally effective as a work for hire arrangement. Here's the practical problem, though. Even if the work for hire clause isn't legally valid, you might not know that. The brand might not know that. And the contract dispute that follows when someone tries to enforce it is expensive, stressful, and time-consuming. So the answer isn't don't worry about work for hire clauses because they probably won't hold up. The answer is flag them before you sign. Understand what the brand is trying to accomplish and negotiate terms you actually agree to. If a brand wants certain rights to your content, there are legitimate ways to structure that. A clearly written license or a copyright assignment with a defined scope is better for everyone than a work for hire clause that may or may not be enforceable and leaves both parties uncertain about who owns what. The third clause is copyright assignment, and this is the one that does what work for hire tries to do, often far more effectively. A license gives someone permission to use your work under specific conditions. You keep ownership. The brand gets the rights they need for a defined purpose for a defined time. When the license ends or its conditions aren't met, the rights revert. An assignment transfers ownership of the copyright itself permanently. If a contract assigns your copyright to the brand, you no longer own what you created. They do. The moment you sign, the copyright leaves you. And unlike many licenses, a copyright assignment generally cannot be undone. There's one notable exception worth knowing. Under Section 203 of the Copyright Act, authors can terminate grants of copyright, including assignments, after 35 years with proper notice. Now, this termination right can't be contracted away in advance, but 35 years is a long time to wait for a piece of content you created last Thursday. The practical guidance, a license that gives the brand the specific rights they actually need for a defined scope and duration, is reasonable. A copyright assignment that transfers permanent ownership of your work is not, and you should push back on it. Negotiate a license instead. Unless, of course, they're willing to pay you an obscene amount of money to own your copyright. Clauses 4 and 5 are related, and they've gotten significantly more complicated over the last couple of years. Clause 4 is about your name, image, voice, and likeness. This is protected under what's called the right of publicity, which varies by state but generally gives you control over the commercial use of your identity. Brands know this, so some contracts include language allowing the brand to use your name, image, voice, or likeness in future campaigns, advertisements, or materials beyond the specific project you're being paid for right now. That's a right of publicity issue. Broad language here can let a brand use your face or voice in ways you never imagined when you signed. Which brings me to Clause 5. And this one I want you to pay really close attention to because it's newer and most creators don't know to look for it yet, but you're going to after today. AI-generated replicas. If a contract includes language permitting the brand to create AI-generated versions of your voice, your likeness, or your content style, stop. Read that carefully before you do anything else. The technology exists right now to clone a creator's voice using a small amount of audio and to generate images and video that look like you, move like you, sound like you, promoting whatever the brand wants, without you in the room, without your additional consent, and without additional payment. Taylor Swift's likeness has been used without her permission in AI-generated deepfakes, including by Meta's AI chatbots and in explicit images that circulated online. Donald Trump shared AI-generated images of her during the 2024 presidential election, falsely suggesting she had endorsed him. She never agreed to any of that. The 2023 SAG-AFTRA strike centered significantly on this issue. Performers were being asked to scan their bodies for digital replicas with no clarity on how these replicas would be used, or for how long, or in what context. That's not a hypothetical. That was a real negotiation that mattered significantly for the performers. So what is Taylor Swift doing about it? Her attorneys, like Matthew McConaughey's, are testing a theory that registering a trademark for specific uses of her voice and image gives her additional legal tools beyond the right of publicity claims to challenge AI-generated content. By filing a sound trademark application on the phrase, "Hey, it's Taylor Swift," spoken in her voice, the theory is that any AI-generated audio that's likely to be confused with that trademark could be challenged as trademark infringement, which can be pursued in federal court and potentially used to issue takedown demands to AI platforms the way copyright claims are. It's a clever approach, and it hasn't been fully tested in court yet. It's just a theory at this point, being explored, and we'll have to stay tuned to see what happens as this progresses through courts, which it inevitably will. I'll keep you informed on that. Here's the other thing. This theory requires resources. It requires the potential to spend a lot of money hiring experienced, large firm IP attorneys to litigate the issues. Now, Taylor Swift has that kind of money, and so does Matthew McConaughey. Most creators don't. So it's great that they're doing this because they may be paving the way for everyone else. States are responding legislatively. Tennessee passed the Elvis Act in 2024, one of the first laws specifically protecting voice and likeness from AI replication. Other states are moving on this. Federal law is still developing. But right now, today, the most accessible protection for most creators is contractual. It's what you agree to when you sign, and that means knowing what to look for. If you see any language about AI, synthetic media, digital replicas, machine-generated content, or broad voice and likeness rights in a contract that involves your appearance, your voice, or your creative style, get a lawyer to look at it before you sign. This is not the place to guess, and the Taylor Swift news tells you exactly why. Clause 6 is about what you can and cannot post on your own channels after the deal is signed. Exclusivity clauses restrict you from working with competing brands during or after the campaign. Now, some exclusivity is reasonable. If you're promoting a fitness brand, they probably have a legitimate interest in you not promoting a direct competitor in the same window. That's a normal business ask. The problem is when these clauses are too broad or too long or too vaguely defined. A clause that says you cannot post any content about competing brands, similar products, or related topics without a clear definition of what competing means for 6 months after the campaign ends can effectively lock you out of your own content lane long after the business relationship with the brand is over. If you're a beauty creator and you sign an exclusivity clause that prevents you from reviewing any other skincare products for 6 months after a single campaign, you've just restricted a significant portion of your content, and that's your livelihood. Read the scope and the duration. Negotiate limits that are proportionate to what the brand actually needs and what they're paying you for. A 1 month exclusivity window during an active campaign is very different from a 6 month post campaign restriction with a vague definition of competing. Clause 7 is about FTC disclosure, and this one matters because it can create legal liability, not just a contract dispute. The Federal Trade Commission, or FTC, requires that paid partnerships, sponsorships, and brand deals be disclosed. The legal standard is clear and conspicuous. That means the disclosure has to be easy to see and easy to understand. It cannot be buried. A hashtag ad buried at the end of a list of 20 hashtags in the caption does not meet the clear and conspicuous standard. The FTC has said this explicitly and has taken enforcement action based on it. In 2016, the FTC reached a consent agreement with Lord & Taylor after it paid fashion influencers to post about a clothing line without disclosing the paid relationship. That same year, the FTC settled with Warner Brothers Home Entertainment over paid influencer posts promoting a video game where the influencers, including some with very large audiences, didn't disclose the posts that were sponsored. Both the brand and the creator can be held liable when disclosures are inadequate. The question your contract needs to clearly answer is who is responsible for drafting the disclosure language and who is responsible for confirming that it meets FTC requirements. If your contract is vague on this and the disclosure turns out to be inadequate, you may be left holding consequences you didn't expect. Don't assume the brand knows what they're doing. Some do, some don't. And the brand told me to post it this way has not historically been a defense the FTC has accepted. The eighth clause is indemnification, and it's the one that can turn a problem you didn't cause into a bill you have to pay. Indemnification clauses define who covers the costs when something goes wrong and there are legal consequences. In a brand deal, a broad indemnification clause can make you responsible for the brand's legal costs, claims, or damages arising from the content, even in situations where the brand directed the content, approved the content, and controlled every aspect of what you were asked to do. That's not hypothetical. If a brand directs you to make a specific claim about a product and that claim turns out to be false or misleading, there may be regulatory or other legal consequences. And if you've signed a broad indemnification clause, the brand may have a contractual basis to require you to cover all or some of their costs. Now, indemnification clauses should be mutual, meaning each party covers the consequences of their own conduct. At a minimum, your indemnification obligations should be limited to things that are actually your fault, your own representations, your own content decisions, your own failure to disclose. You should not be indemnifying a brand for claims arising from the brand's own direction, approval, or conduct. If you see a one-sided indemnification clause that puts all the risk on you, or at least a big chunk of the risk on you, regardless of who caused the problem, that's worth pushing back on before you sign. Those are the 8 clauses, and I know that's a lot to hold on to at once. Here's what I want you to take away. You don't need to memorize all of this. You don't need to become a copyright or trademark attorney before you sign a brand deal. You just need to know what questions to ask before you sign, and what to do if the answer to any of those questions is concerning. That's exactly why I put together the brand deal red flags checklist. 8 questions based on everything we just talked about in plain English with a brief explanation of why each clause matters and what a red flag looks like. Run through it before your next brand deal. If you check any of the boxes, that's the moment to get a lawyer to look at the contract before you sign, not after. And that means a lawyer who's licensed to practice in the state in which the contract is based. The checklist is free. Download it at kingpatentlaw.com or use the link in the description. And one more thing worth saying directly, the cost of an IP attorney reviewing a brand deal contract is a fraction of the cost of trying to undo rights you've already signed away. And some rights, once assigned, cannot be undone at any price. The review is worth it. If you found this episode useful, please subscribe and leave a review on Apple Podcasts or wherever you're listening. It genuinely helps other creators find this information when they need it. Download the Brand Deal Red Flags checklist at kingpatentlaw.com or use the link in the description. And if you have questions about a specific contract or about your copyright, trademark, or patent rights, I help creators and small business owners with IP matters nationwide and with contracts in Illinois and Georgia. Book a consultation at kingpatentlaw.com. I'm Julie King. Avoid the legal horrors and keep rocking your IP. Thank you for listening. This information is for educational purposes only, is not legal advice, and does not form an attorney-client relationship. For advice about your specific situation, consult with a licensed attorney. This episode contains attorney advertising material. Firm address and contact information are available at kingpatentlaw.com.